con law essay question from February of 2004 is about as straightforward and easy a con law essay question as you can hope to see on the California bar examination. And if you want proof, just turn to the call of the question. 1. How should the court rule on the department's motion to dismiss on the ground of ACA's lack of standing? Discuss. Are you kidding? This is about as simple a question as you can get, and all you need to know to be able to answer it is, first, the elements of association standing, and, secondly, you've got to be fluent enough in the English language to be able to pick out the key facts and connect them with that three-step analysis. So, the first call of the question is a giveaway, practically. Question 2. On the assumption that ACA has standing, how should the court decide ACA's claim that the State X statute is invalid under the Commerce Clause and the Supremacy Clause of the U.S. Constitution? Discuss. Again, this is a very simple, straightforward call of the question. All we're being asked to do is a Commerce Clause and a Supremacy Clause analysis. It's pretty simple, and we know that the Supremacy Clause is easy. The Commerce Clause can be fairly complicated, but in this question, as it turns out, this also is relatively simple. So, up front in the approach, I suggested that con law is a lot harder on the essays than it is on the multi-state. This essay question is about as simple and straightforward as they come. And that doesn't mean that there are not a couple of rather complex little bits in here, but basically this is pretty easy business. Let's have a look at the fact pattern briefly. In paragraph 1, we find out about a federal agency known as the National Highway Transportation and Safety Administration. They have appropriate hearings and they do their investigations. And they make a finding of fact which is listed and quoted in paragraph 1. And that finding, not to read it aloud, indicates that motor vehicle radar detectors have some good use in alerting drivers to their speed. But most of the time, these devices are used to facilitate speeding and to avoid being caught by the police. So, because of this finding, the National Highway Transportation and Safety Administration bans the use of radar detectors on big trucks on all roads and highways in the United States. Okay, that's the underlying federal finding. But remember, this cause of action, the questions that we are being asked, involve a State X statute. So here we are. We've read 1/3 of the fact pattern, and all we know now is about something that has happened on the federal level. Well, look at paragraph 2. Here, State X later on enacts a statute that bans the use of radar detectors in any motor vehicle, on any road, on any highway in State X. And the State X Highway Department enforces this statute. Well, let's just stop right there for a moment. We've got a federal finding that appears to be more or less on point. And here we have State X going beyond the federal regulations. We can analogize to other constitutional law issues here. If the state of California wants to afford speech greater protection than that afforded at the federal level, California is free to do so. And by analogy, it seems to me that our first reaction to the State X statute should be no problem, because it may go a little farther than the federal statute, but we would expect that that could well be within the realm of what the state has the power to do. So, now go to paragraph 3, and here we meet ACA, the American Car Association. This is an association made up of drivers, and one of their purposes is to promote free and unimpeded automobile travel. And ACA has heard from its members about this statute in State X. The members don't like it very much, and as a result, we find in paragraph 4 that State X now is a defendant in federal court as a result of the lawsuit filed by ACA. And we're told in paragraph 4 that the claim is Commerce Clause and Supremacy Clause, and we've got the department's motion to dismiss. So that sets up the call of the question that we've already had a look at. Now, please have a look at my outline of issues, and you'll see here there's nothing really imaginative to do. And in fact, there is so little law that we've got to spend more than half of our time using the facts as an organizing principle. Well, as predicted, our answer to the first call of the question is so easy to organize, we don't need to go beyond what we were likely able to do at the moment our eyes first looked at the words in that question. Okay, it's association standing. What are the elements? Well, in letter A, I focus on whether or not the litigation is relevant to the association's purpose. It is. I ask whether or not individual members would have standing. It appears they would. No participation by individual members, and then a conclusion. I'm in favor of a finding of association standing here. Next, we get to by far the more complicated set of issues, although in relative terms, this still is pretty simple compared to some stuff that we're going to look at in other fact patterns. Here we've got a Commerce Clause and a Supremacy Clause analysis. And as you look at my outline, you'll see I don't have anything to say about the Supremacy Clause other than to list it. I'll take a look at it in more depth when we get to a review of our answer. But there's no internal organization. The Commerce Clause, however, affords a somewhat better opportunity to carefully organize our thoughts. This is the core of the problem in my mind. This is where we have to do our clever analysis, because we can expect just about everybody is likely to know association standing. And we rely on technique where knowledge fails us. But with the Commerce Clause, again, it isn't as if there are a lot of elements. So, first, I focus on the police power, and I use as a heading the idea that speed limits are a reasonable exercise of the police power. I indicate, secondly, that banning the use of radar detectors does not unreasonably burden commerce. It isn't as if the state is forbidding possession. They are merely banning use. Thirdly, the State X law does not discriminate against other states. And then, finally, the State X law doesn't violate the Commerce Clause. That's my conclusion. Are these headings essential? Of course not. It's possible to compress this into a couple of big fat paragraphs, and some people actually got passing scores by doing precisely that. So this idea of using facts as headings certainly is not essential. But I think you can see fairly quickly how easy it is to do this, and how helpful it is, not only for organizing our thoughts, but perhaps more importantly, for organizing the grader, so that the grader is able to pay attention in between cocktails and figure out that you know what you're doing. So the bottom line is, I conclude that the association's constitutional challenges to this statute will fail. That's how the analysis is structured. And now, briefly for a couple of minutes, let's have a look at my answer to this question. And I'll make a couple of additional points about areas that you might have an additional look at. We begin at the top of page 1 with regard to the association standing issue. You'll notice up front, I don't just jump into association standing. I put a couple of paragraphs up front to set up the analysis. I indicate who the plaintiff is. I indicate who the defendant is. And I indicate the procedural status of the case. There's been a motion to dismiss on the grounds of association standing. Then, in paragraph 2, I state the law. Why do I do that? After I spend all of this time in other videos advising you against boilerplate definitions. Well, the answer, to be entirely honest, is this. I think this fact pattern is so thin, and the issues so easy, that I have the time to be able to recite the law in a way that usually I don't feel I have the time. Hence, paragraph 2, you actually get a coherent, complete, almost hornbook definition of association standing. Okay, great. Now let's actually do the analysis. And that's what follows in sections A, B, and C. Substantively, I've already reviewed these ideas enough that I don't feel the need to repeat myself here. But have a look at these 3 paragraphs. I think you'll see here how complete a job I do in finding a home for the facts. Our job is to report accurately on the details of the question and analyze their impact. So we can see, given how thin this problem really is in terms of issues presented, I really stretch out and do as comprehensive and thorough a job as I possibly can. So, finally, by the conclusion, everybody, I think, will be on the same page and agree that here the association satisfies all three line item requirements for association standing. And here, to be honest with you, I think this is one example where we have a clear-cut correct answer. I really can't imagine somebody concluding that there is no association standing here and still getting a passing score. I never saw it happen. And actually, you know my real opinion. The core of this problem is in part 2. That's where the real con law issues lie. So let's take a quick look and see how I have chosen to flesh out the organization that we've already reviewed. Look up front, and you can see, as usually is the case, I lead with the facts. I indicate that the core of ACA's action is to seek a declaration that this is an invalid statute because of the Commerce Clause and the Supremacy Clause. Up front, I indicate that both of these challenges are going to fail. Now, here's another little sidebar. Is it necessary to telegraph our conclusions like this? No, not in California. Some jurisdictions, notably New York, basically require that candidates state the answer up front and then justify that answer. That kind of rigorous format is not required in California. But often, I do think it's helpful to set up the analysis and basically answer the question up front. And here we have an example of where I think that technique can be useful. So we turn now to the Commerce Clause. Up front, I actually state a definition of the Commerce Clause. You can agree or disagree with how good a definition it is, but I think you can also agree this does convey the basic meaning of the Commerce Clause. So once you get a fact pattern on the California bar that is this easy, that gives us this much time, go ahead and put in your more elaborate definitions. But what is far more important in this Commerce Clause analysis, far more important than my definition, is my analysis with regard to parts 1 through 4 below. My analysis of the police power, the banning of the use of radar detectors not being an unreasonable burden, and a lack of discrimination. These are ideas that are at the core of the Commerce Clause. And I think you'll understand and agree, really, the first time you look at this material, that what I've done here is both accurate and complete. I found a home for all of the relevant facts, and I've presented them in a context that shows that I understand the Commerce Clause. Remember, the basic job that we have on this exam is establishing our competence, and that means hitting the issues, breaking them into elements, finding a home for the facts. So we conclude that the Commerce Clause will not be a bar to enforcing this State X law. We move on to the Supremacy Clause. And here again, I think this issue is so light, so thin, that I actually spend a little bit of time talking about the law up front. And also, in the third paragraph of analysis, I suggest that the State X law actually furthers and advances the purpose of the NHTSA regulation. So rather than being inconsistent with a conflicting federal clause, I find that the State X clause actually is consistent with the federal legislation, which is one more compelling reason why we should not sustain a challenge to the law based on the Supremacy Clause. So, at the very end, I offer a succinct bottom line. ACA's constitutional challenges to this State X law will fail.